Great. You only have one case there. That's Kevin Tipton. So let me see Mr. Tipton first. We'll take the counties from the smallest number to the largest, just kind of more practical. Mr. Tipton, good morning. Mr. Tipton, you're here because you're accused of one count of battery in case 25335 CF. Mr. Tipton, this is filed as a second offense battery. It's filed as a felony charge against you. I have read the complaint, Mr. Tipton. There is probable cause. Mr. Tipton, when a judge finds probable cause, that does not mean that you're guilty of the offense. It simply means there's enough evidence in a sworn under oath complaint to lead a reasonable person to believe you may have committed the crime that you've been accused of. It's a pretty low burden, but there is probable cause. The problem is, I believe Mr. Gill has texted me that you're on probation, on state probation already. Is that correct, Mr. Gill?
Yes, sir. I'm showing that he's on probation in case 24 CF 525.
Okay. Anything else, Mr. Gill, on behalf of the state?
We would just be asking that the court revoke his bond in that case and that there be no contact with the alleged victim in this case, and we're asking for a reasonable bond.
And you said revoke bond. I'm assuming you meant hold him to give probation time to do their due diligence? Yes,
Your Honor, just to hold, and then for the VOP, thank you. Yes.
Ms. Simpson, anything on behalf of Mr. Tipton?
No, Your Honor.
So, Mr. Tipton, when you have a new charge, and I believe you're actually on probation for battery on the same person, I believe, Mr. Tipton. So what I'm going to do is set your bond to the new case because you're entitled to one, but it can get a little confusing. Your bond in the new case is going to be $10,000 cash or surety. Do not try to post it, because even if you post it, you won't get out, because I'm going to hold you with no bond for 10 days for possible bond violation. That 10 days starts the first day the state can notify the probation office, which will be tomorrow. 10 days starts tomorrow. They have 10 days to seek a warrant. If they get a warrant from the probation judge, the VOP judge, in that case, that judge will be the one to decide if you get a bond in the VOP or not. So even though you've got a bond in the new case, don't try to post the bond because you won't get out. I will see you in 10 days, or a judge will see you in 10 days. If that 10 days falls on a weekend or holiday, you'll get seen the next working day. And if there's a warrant for the VOP, you'll find that out, and you'll find out there's a bond. If there's no warrant for the VOP, that 10-day hold will be released, and you'll be free to post a bond in the new charge. You do have a condition of no contact with the alleged victim at all. I know that the VOP, when I read it, there was a condition, no violent contact. This condition in this case is no contact at all. So if at any point you're on bond in this case, there's no contact at all, the no violent contact doesn't apply anymore, at least not in the new case. Mr. Tipton, do you have any questions?
No, sir.
All right, sir. Have a good day.
Thank you.
And Mr. Jailer, I think that's it for Jackson. Is that correct?
Yes, sir. You have a good day.
Thank you. Have a good day. The next county that has the next fewest cases is Gulf County, which only has 2 cases. And Mr. or Madam Jailer, can you see us hear us okay in Gulf County?
Yes, sir.
Great. And have you had a chance to play your first appearance video?
Yes, sir.
Great. First case in Gulf County is Cheyenne Gray. Ms. Gray, good morning. Ms. Gray, you're here because you've been accused of 1 count of domestic battery and 1 count of criminal mischief under $1,000. I've read the complaint. There is probable cause for the charges. Ms. Gray, it appears you're already on probation in a misdemeanor case in Gulf County. Is that right, ma'am?
Yes, sir.
So your situation is similar. I'm going to set you a bond in these cases. They're misdemeanor charges. Your bond's going to be $5,000 each. It's $10,000 total, with a condition of no contact with the alleged victim. Do not try to post a bond because you're on probation. I'm going to hold you for 10 days or until you see the Gulf County judge. Let me explain. Some counties don't do a 10-day hold. Some counties will do a shorter hold or even a longer hold. So that'll be Judge McFarland's decision. So you'll see him. He may change that 10 days to another number. But for right now, there's a 10-day hold. I'm going to ask Mr. Gill to notify the probation office in Gulf County of your arrest. Mr. Gill, it looks like 25-03MM is the case number she's on probation for in Gulf County, and it is also a battery charge like today. So, Ms. Gray, you get to contact friends or family and tell them what's going on, but there's no point trying to post bond because I'm holding you for possible violation of probation. Ms. Gray, you do have a condition, no contact. I think I may have already said that. Do you have any questions?
No, sir.
Have a good day, ma'am. Lenny Toshay.
Yes, sir.
Mr. Touche, good morning. Mr. Touche, you're here for a child support issue. It looks to me like you've got a purge amount already set on there of $2,500. This is not a criminal matter. This is a civil child support matter. So the way the child support works is you have the right to post the purge. If you do, you'll be released. If you can't or don't post it, Within 2 working days of the arrest, you'll go before a child support hearing officer or a judge for what's called a 48-hour hearing. That child support hearing officer or judge may or may not lower the purge. So what that means is you get to use the phone after first appearance to contact friends or family. If you can't come up with a $2,500, you may want to see what you can come up with, because the child support hearing officer very well may ask you that question in the next 2 days. For instance, sometimes people say, Judge, I can come up with $1,000. I can come up with $1,500. And sometimes the hearing officer may lower it to that amount. So that's going to happen in the next 2 working days. Any questions,
Yes,
sir?
sir. No, sir.
Wish you the best.
Thank you.
Mr. Jailer, thank you. Mr. Jailer, anything else in Gulf?
Yes, sir. He also has a contempt of court warrant. Don't know if you've seen that in the very back.
Okay, let me check that. Come on back up then, Mr. Toshay. Child support is a contempt of court, so when it said it on here, I thought that was one and the same, but you may have a different contempt of court matter going on.
Yes,
I did
sir. The
not
last page I sent you should be a contempt of court
Okay.
warrant.
All right. I may have missed that. That's certainly possible and unfortunately pretty common. All right. So there is an arrest order. Let's see what this is. This is Gulf County case 25-CT, 25-43CT. It's a criminal charge for the CT means criminal traffic. What it says is that you pled to the charge of driving while license suspended. This is dated May 7th. It says on May 7th you pled. You were ordered to pay court costs and fines of $513 by July 2nd or spend 10 days in jail. You requested additional time to pay the fine, and you were granted that additional time, and they were then due by August 1st, and you still failed to pay them by August 1st, and the warrant was issued. So you have a 10-day jail sentence that has been imposed. So that doesn't change anything I told you about the child support matter. You still will see a hearing officer. I do not see if there's a purge on here. Actually, no, well, I'm sorry. Let me clarify this. This is different than the way different counties do it differently. What this says is when you didn't pay it, the 10-day sentence became a 30-day sentence, and you can purge yourself and be released at any time before you complete the sentence by paying the same amount that you were ordered to pay to begin with, which is $513. Madam Jailer, will he see Judge McFarland the next business day to clarify all
No,
this?
not typically, sir. No, sir.
Okay.
Whatever you said.
Well, it looks like it's gone from 10 to 30, and that may be intentional. I don't know. That may be the way Judge McFarland does these sentences. I would like for him to see Judge McFarland just to make sure that I'm not assuming or misreading anything, because I haven't seen this exact order before. So you have 2 matters. You've got the child support matter. You've got this criminal matter, and I'll ask the jail to get you back in front of Judge McFarland the next working day that he's here, which will likely be tomorrow. Mr. Toshay, any questions?
No, sir. Thank you.
Thank you. Madam Jailer, thank you. We'll see you next time.
Yes, sir. Thank you.
All right, let's talk about that. This first appearance session moved between counties, with Judge keeping things organized despite very different cases and circumstances. It started with Kevin Tipton in Jackson County, charged with felony battery. As a second offense, probable cause was found. But the bigger issue was that Tipton is already on probation apparently for battery against the same alleged victim. The judge set a $10,000 bond on the new charge but made it clear he'd be held for 10 days to give probation time to file a VOP warrant. Even if Tipton could post bond on the new case, he wouldn't be released until that hold expired or the probation judge made a decision. A no-contact order replaced the previous no violent contact condition, tightening the restrictions. Then we shifted to Gulf County for Cheyenne Gray, accused of misdemeanor domestic battery and criminal mischief. Like Tipton, she's already on probation also for a battery case. Bond was set at $5,000 per count, $10,000 total with no contact. But she's also being held for up to 10 days pending possible VOP action. The judge explained that local practice might change that length, depending on Judge McFarland's decision, and directed notification to the probation office. Next came Lenny Toshay, whose case was a mix of civil and criminal matters. The first was a child support issue with a $25 purge amount, meaning he could secure release by paying that sum. If not, he'd see a hearing officer within 2 working days who might lower the purge based on what he could afford. That alone would have been simple enough. But then the court uncovered a separate contempt of court criminal traffic case for driving on a suspended license. Toshay had been given time to pay $513 in costs and fines. missed the extended deadline and triggered a jail sentence. The sentence expanded from 10 to 30 days, but he could still purge himself by paying the same $513 at any point. The judge wanted him in front of Judge McFarland the next working day to make sure there was no misunderstanding about the sentence structure. Across the board, the judge's tone stayed consistent. Explain the process, clarify bond and hold rules, and ensure defendants understood what actions, if any, could change their immediate situation. Whether it was a felony battery, a misdemeanor probation hold, or a child support purge, each person left knowing exactly what the next step was. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.